welcome back to Litigation Help. My name is Heather Hui Twin, and today we're going to talk about conferences in family law proceedings. Now, please do keep in mind that our videos are not legal advice, and it is information that's based on the legal system in Ontario, Canada. So joining me here again is our regular family lawyer expert, Helena Burt. Hi, Helena.
Hey, Heather, how are you?
I'm great. Okay, so Helena, first of all, could you give us like an overview of the main stages that one might expect in a typical family lawsuit?
Yeah, the family law rules actually do set out a pretty clear process. So assuming you can't get your matter settled at any point in the proceedings, there is a series of steps that pretty well every case generally goes through. But as I said, it can be stopped at any stage in the proceedings because if people can settle it, you don't have to go right from start to finish. But generally, the way that it works is when somebody has to start something in court or they're responding to it, there is an application or a motion to change that is started. The other side then has to file an answer to the application or the motion to change. And once they've got that, it's like in civil, it's like a claim and a defense or a claim and a counterclaim. Then once they've done that documentation, so people know what the whole overall case is about, then you start going through the conferencing processes. And you've got a case conference, which is going to be the first type of conference we talk about. Normally, after a first conference has been done and issues aren't resolved or settled, then either party can then bring a motion if they're looking for getting an order for temporary relief, because it could be a year or 2 or 3 years before the matter goes to trial. And sometimes you need an order made in the middle, but you do then. So it's the answer and the application are exchanged. Then you have a case conference. Then if either party feels they need to bring a motion, they can. Then the next phase in the process would be a settlement conference. And then the next phase would be, if you can't settle at that point, a trial management conference where you're really starting to focus on saying, okay, we got to start getting this thing ready because we're going to trial. Then you have the actual trial, the hearing itself. If somebody's not happy with the trial decision, there's the potential for an appeal, which is a really crazy making thing. And I think we either talked about appeals or we've talked about talking about appeals. And then in some cases, once you've got a final order, then a motion to, or in an application, then you might be coming back to court on a motion to change and you start the whole process all over again. So that's pretty well what it looks like from start to finish. And that's where the conferences are a really important part of that, because they're steps that the rules specifically call for as you're working your way towards the trial, in the hopes that the parties can actually work out an agreement between themselves. So they're not leaving a decision dealing with their family lives in the hands of a judge. They're trying to get people to resolve matters on their own, if at all possible.
You mentioned, at least, I guess, you mentioned 3 types of conferences. So let's start with the case conference.
Now, the case conference is very early stage. As I said, once somebody initiates a court proceeding, there's an application that's served on the other party and then filed with the court, then the other party does their answer. Once that documentation is done, then the rules call for a case conference to be held. And actually, there are a lot of sources, including the Law Society of Ontario, that acknowledges that the case conference is probably the most important step in the family law litigation. You can't bring a motion, because we talked about that before. If you're looking for temporary relief, you can't serve a motion or have a motion argued until you've had a case conference dealing with the issues, unless there's a situation of urgency or hardship, or a case conference is not required for some other reason. But generally, you can't even ask to go before a judge to argue something until you've had that first case conference. If you're in a location where you've got an Ontario Court of Justice or a Unified Family Court, then the case conference date is actually set out right in the application, like the initiating documentation that sets the matter into court. If you're in a Superior Court jurisdiction, which is not a Unified Family Court, then it's not contained on the application form. The application gets served, the other party has to serve and file an answer. And then you can ask the clerk of the court to set a date for the case conference. So it's not done automatically as it is in an Ontario Court of Justice or a Unified Family Court. If you're in a Superior Court of Justice that's not a Unified Family Court, you have to ask the clerk for a case conference date. And the clerk won't give it to you until people have done that initial documentation, the application and the answer. Okay, so basically why the case conference is so important. It's going to be the first time in your case that the parties are actually with a judge. The case conference was created to allow the litigants and their lawyers, if they have them, to hear what a judge actually thinks about the case early on, before people have spent thousands of dollars in lawyers' fees and non-motions and other expensive steps in the court proceedings. So again, the reason for this is it gives you a chance to sit down with a judge who can tell you what he or she thinks and say, geez, if I was hearing this matter and based on what's on the material before me, if this was going to a trial, this is going to be what I see as the likely outcome. So it really tends to encourage people to take a really hard look at what they're asking for or what they're expecting the court to do. And it'll help them decide, geez, do I really want to proceed with this? Because if I'm never going to succeed at this, why am I even bothering trying? So it's a chance for the parties to sit down with the judge to get that kind of feedback. And the family law rules actually set out all of the things that are expected to happen at a case conference. The purposes are to explore the chances of settling a case. And again, as I said, quite often, usually, the judge who's meeting with the parties at a case conference will explain what the law is and how it applies to the facts in the case that's based on the materials that have been filed already. And the judge can give an opinion on the probability of any position that a party may take. The judge will help people to explore ways of resolving issues that are in dispute. And even if you can't solve everything, if you can resolve some issues, either on a temporary or permanent basis, that's lesser things that you're going to have to argue about later on if you have to continue on in court. The case conference will make sure that people have provided the relevant disclosure and the disclosure that's required by the rules, like especially the financial disclosure. So that's something that a judge can actually do at a case conference without the party's consent, is that if somebody hasn't provided the financial disclosure that's required by the rules when they did their application or their answer, judge can order it at a conference, which is unusual because there are certain things that a judge can order at a case conference to help make sure that people are following the rules. If people haven't done something the rules tell them to do, the judge can make an order against the person to do what the rules have told them to do and give them a deadline for doing it, even if the parties don't agree to it. But when you're talking about substantive issues like parenting issues or support issues or property issues, a judge at a case conference cannot make an order unless the parties agree to it, because the whole point of the conference is to see if there's any room for settlement or negotiation. If the parties don't come to an agreement on what to do on the substantive issues, then the case will get moved along to the next step. Also, case conferences can be really helpful in flagging for people if there are issues that might require professional or expert evidence, like a parenting assessment or a financial forensics accounting report or whatever. It can help point out whether you're going to need one of those or not. And it's to set the next date for the next step in the case, because there are some cases that settle everything at a case conference, but that's rare. But at least you can get started on saying, okay, are there things we can agree to either on a temporary or final basis? What are the issues we still have to deal with? What do we need to get done on those issues before we come back on the next step in the process? So then the next thing that you can do is then, because you've got all that, so you're setting a timetable for any disclosure that's still outstanding. If there's any documents that still have to be filed, all of that can be dealt with at a case conference. Then what the judge is doing is then getting you ready for the next step, which would be a settlement conference. Saying, okay, we've had our initial meeting. Everybody's good to go. We know where we're at. We figured out what we can settle now. Okay, there are issues we haven't settled. What does everybody need to do before you come back on a settlement conference, which would be the next step? Sometimes what will happen is at the case conference, it'll really make parties realize what their issues are. They're really, really just saying, no, we will never be able to agree on this. We need to have this argued before a judge. And that, once you've done that first case conference, then you can go ahead and schedule a motion to actually go in and present evidence and argue in front of a judge who will not be the judge that sat on the case conference. Because everything that happens in a case conference is privileged. It's to encourage discussion. So that judge is there to facilitate settlement. The judge is going to hear people make offers. The judge is going to suggest means of getting things resolved. If there are issues that are saying, no, we need to get this argued and I need an order now, placing the children in my care, and the parties can't agree who the kids are to be with, then once you've done your case conference, then you can bring a motion. But you can't bring a motion until you've actually done your case conference. So what a judge can also do at that case conference is give directions with respect to any motion the parties say that either one of them wants to bring. And that can include setting deadlines for your exchanging materials so that the parties really are using their time efficiently. And when it does come before a judge on the motion, that they are ready to go. Okay, so and then for attending a case conference, I think it's going to actually be one of the things we talked about as well, is that if you have counsel, you can't just send your lawyer on your behalf. The whole point of the case conference is for the judge to actually sit down with the parties and look them straight in the eye and be able to work with the parties about whether in fact there are issues that can be settled. The lawyer can, and if you do have counsel, should be attending with you, but you can't just send your lawyer on their own. You have to be there for the conference. During COVID, conferences have been happening via Zoom. Now there are, depending on the jurisdiction you're in, you might have an option about whether you do a settlement conference in person or if you do it by Zoom. If you fail to attend a conference that's been scheduled, you could have costs ordered against you because it's a really, really important step. You can't just say, well, I'm just getting over this hurdle so I can bring my motion or do what has to be done. So there can be cost consequences for failing to show up at a case conference. So in addition to the normal documentation that you need just for your lawsuit, your family law application, each party has to serve and file a case conference brief before every conference. So it's in addition to the normal stuff that you do that's part of the lawsuit. And you have to file the brief at least 6 days before the date that's scheduled for the conference. So that would normally be, again, the applicant, the one that started the application, would have to serve and file their brief 6 days before the date of the conference. Once they've served the other side, then the other party has to serve and file their brief not later than 4 days before the conference. And once they've been served, then both parties have to file their briefs with the court. The interesting thing though about the briefs is they don't form part of the continuing record. They go into the court file so the judge can see what the parties are saying, and that the briefs basically summarize what the parties are looking for and what their positions are on different things, so the judge can have a chance to read all that before having the case conference. But once the case conference is heard, 99 times out of 100, what will happen is the briefs are taken out of the file and they're given back to the parties, because you don't want a judge that's going to be going to trial seeing what the offers to settle are and things that might be going back and forth that are set out in the briefs. So, and again, it's a technical process. Not later than 2 p.m., 3 days before the conference, both parties have to file confirmation just to say, yep, we've done everything we have to do. Yep, we filed everything. We've served everything. We are proceeding, because nothing is going to make a judge more ticked off than showing up for conference and the parties show up and say, oh, Your Honor, we just want an adjournment because we're not ready to proceed today. So you have to get your confirmation done 3 days before the date of the conference. Okay, so as I indicated before, at a case conference, a judge can make orders for disclosure, or if there's a need to have property preserved, like if somebody owns an asset that is subject to the equalization process, and one party is afraid the other might be putting it up for sale or marketing it, the court can make an order preserving the property, even if a party doesn't agree to it at a case conference. But as I said, if you're looking at any of the substantive issues, they have to be on consent. And that includes an order that refers any issue to mediation or any other type of alternative dispute resolution. So the goal at a case conference is try to reach an agreement, be it final or temporary, some issues or as many issues as you can possibly do. Again, any brief that's done for a conference, or if there's an offer to settle made, can't get shared with another later judge. It's strictly there to let the judge deal with it at the case conference to try to get people to settle as much as they can. So all negotiations, suggestions, guidance that the judge gives at a conference, they're not recorded or admissible in any future steps. Like, it's meant to be privileged so parties can speak their minds, they can make whatever offers they want, and they're not going to be held to it later on. It's, again, the mechanism to try to get parties to settle and speak their minds. So that's how a case conference works.
So what happened, because you mentioned that the case conference judge can make an order, for example, compel the other side, compel a party to disclose documents. What happens if they don't?
If the judge makes an order for disclosure and the person fails to make that disclosure,
what happens?
The judge can draw, like later on down the road, because if you need that, if that disclosure is required for the purposes of determining an appropriate amount of support or a property question, the court can draw an adverse inference for failing to provide that disclosure, which means if the other side has got evidence or documentation that seems to establish the value of something or how much a person actually makes, but the person hasn't done their financial disclosure, If you fail to do the disclosure that's required by an order, then the court will proceed on the evidence that's available to them. And you might have to say, well, that's not right. I've got evidence that shows that's not true. Well, then you should have filed it. So again, it's the whole thing about making an adverse inference. The judge or a court eventually, if there's no consent, can end up making an order that goes against that person without that disclosure being made, because the judge saying, okay, then I'm obviously expecting that what that information that was supposed to be disclosed does disclose is that that asset is worth what the other party is saying, or maybe even more. Or at the very least, what I can do is have cost consequences for failing to produce an order.
Now, I know in a lot of self-reps, including myself, we thought that if our opposing party does not obey an order, we can bring a motion for contempt. Is that true? I mean, that's a big, a very harsh mechanism to bring on. But I know that people have always said, oh, if the other side doesn't obey an order, I can bring a motion for contempt. Is that appropriate?
There is a process in the family law rules for bringing a motion for contempt, but you're usually only going to use it in a situation where you're dealing with a final order after everything's been resolved and somebody is in breach of a final judgment or an order. Right. This stuff is you're fighting and jockeying for position on how the matter is going to unfold. There are other things a judge can do to really slam somebody that's failing to do what they're required to do in this process. One of the things ultimately that a court can do without a contempt motion is if there is an order for financial disclosure that is made and a party refuses to file their financial disclosure, the court can strike their pleadings and basically say, we're going to just wipe out everything you're trying to claim. Any of your defenses, claims made by the other party, we're wiping them out. And we're just going to proceed as if it was like you never filed a response to what you're asking for or what the other side is asking for.
Okay, so let's say that my opposing party is a pain in the neck and they have not disclosed. So we now come to the settlement conference. Can I do, so it's up to me to ask judge, can you strike out their pleadings? Like, is it up to the party?
You would have to. Again, that's what the judge will be asking for. If there was an order specifically made for financial disclosure and somebody has breached that order, they better have a pretty good explanation for it.
Okay.
But if they don't, because what the judge will do is advise that party that the innocent party can bring a motion to have the defense struck. Yeah. But yeah, the judge won't do it. Like the party has to ask the court to make that. And then again, so they've got to do it by way of a motion or whatever. But.
Oh, that's okay.